How long is this actually going to take? It's one of the first questions people ask once they start thinking seriously about divorce. And in California, there's one number that answers part of it right away: 6 months, at an absolute minimum. Let's walk through why and what realistically stretches that timeline further. California Family Code Section 2339 sets a mandatory 6-month and 1-day waiting period before any divorce can be finalized. This is a hard floor. It doesn't matter if you and your spouse agree on absolutely everything. It doesn't matter how long you've already been separated, and no judge can waive it. Here's the detail that trips people up most. The clock starts on the date your spouse is served, not the date you filed your petition. If you file on January 1st but don't serve your spouse until February 1st, the earliest possible finalization date moves out to early August, 6 months from the service date, not the filing date. One note on the newer joint petition process, Form FL 700, available since January 1st, 2026. Because both spouses file together and the petition is deemed served the moment it's filed, the 6-month clock starts at filing instead. That's specific to that one path. The traditional petition and response process still runs from the date of service. So what does a realistic timeline actually look like? Let's start with an uncontested case, where both spouses agree on the major issues. Filing generally takes about a week to prepare. Serving your spouse typically takes another 1 to 2 weeks. From service, there's a 30-day window for a response. Financial disclosures generally take another 30 to 60 days to exchange. Add time to negotiate and finalize a written agreement, and you're generally sitting somewhere in the 3 to 4 month range before the 6-month waiting period has even finished running. Once that 6-month mark passes and your judgment paperwork is ready, the court generally takes another 1 to 4 weeks to process it. Altogether, most uncontested cases land around 6 to 8 months. A contested case, where you and your spouse disagree on one or more major issues, looks very different. Filing and service still take a few weeks, but then you're generally looking at months for discovery and gathering financial information, months more if custody mediation or evaluation is needed, settlement conferences, trial preparation, and if it comes to that, an actual trial. Contested cases commonly take 1 to 3 years, and more complex ones can run longer. Court backlogs make a real difference here, too. Some larger counties can take 18 months or more just to get a trial date, while smaller counties are often faster. There's also the default timeline, which applies when your spouse is served but never files a response within 30 days. A default case can move forward without your spouse's participation based on what you requested in your petition. Even so, you still need to complete financial disclosures and wait out the same 6-month period. So a default case generally still lands around 6 to 8 months, similar to an uncontested one, just without needing your spouse to actively cooperate. So what actually stretches these timelines beyond their floor? A few things come up again and again. Incomplete or incorrect paperwork that has to be resubmitted, failed attempts at service that have to be tried again, missing financial disclosures which can block a judgment even after the 6-month period has passed, filing in the wrong county, and simply not responding when the court requests additional information. On the dispute side, custody issues, contested support calculations, and complex property division, especially anything involving a business, retirement accounts, or property in more than one state, tend to add the most time. None of these delays are required. A few habits help keep a case moving at its natural pace instead of slower. Start your financial disclosures right after filing rather than waiting, since this step alone commonly holds up an otherwise ready case. Double-check your paperwork for completeness before submitting, since a rejected filing costs more time than a careful first pass would have, and confirm your service was done correctly and filed promptly, since an inaccurate or late proof of service pushes back the one date that actually starts your clock. The 6-month wait itself is fixed, but almost everything that adds time beyond it comes down to paperwork accuracy and timing, which is exactly the kind of thing a guided process can help with. Virdix walks you through the forms for your California case in plain language, so your filing, service paperwork, and disclosures are complete and consistent from the start, which keeps your case moving at its natural pace instead of getting stuck on an avoidable mistake. Virdix is a document preparation service, not a law firm, so this is not legal advice, and for advice about your specific situation, talk to a licensed attorney. You can start at virdix.co.